Hello! Welcome to the Study With Me series of Law School Buddy. I have prepared audiobook materials following the syllabus of the Philippine bar exams dedicated to our law school students. I hope that this audiobook can help with your study and review. Let's begin. This episode will cover Property Law, Title 7, Easements of Servitudes, Chapter 2, Legal Easements, Section 7, Intermediate Distances and Works for Certain Constructions and Plantings, Article 677. No constructions can be built or plantings made near fortified places or fortresses without compliance with the conditions required in special laws, ordinances, and regulations relating thereto. Article 678. No person shall build any aqueduct, well, sewer, furnace, forge, chimney, stable, depository of corrosive substances, machinery, or factory, which by reason of its nature or products is dangerous or noxious, without observing the distances prescribed by the regulations and customs of the place, and without making the necessary protective works, subject, in regard to the manner thereof, to the conditions prescribed by such regulations. These prohibitions cannot be altered or announced by stipulation on the part of the adjoining proprietors. In the absence of regulations, such precautions shall be taken as may be considered necessary, in order to avoid any damage to the neighboring lands or tenements. Article 679. No trees shall be planted near a tenement, or piece of land belonging to another, except at the distance authorized by the ordinances or customs of the place, and in the absence thereof, at a distance of at least 2 meters. From the dividing line of the estates if tall trees are planted, and at a distance of at least 50 centimeters, if shrubs or small trees are planted. Every landowner shall have the right to demand that trees hereafter planted at a shorter distance from his land or tenement be uprooted. The provisions of this article also apply to trees which have grown spontaneously. Article 680. If the branches of any tree should extend over a neighboring estate, tenement, garden or yard, the owner of the latter shall have the right to demand that they be cut off insofar as they may spread over his property. And if it be the roots of a neighboring tree, which should penetrate into the land of another, the latter may cut them off himself within his property. Article 681. Fruits naturally falling upon adjacent land belong to the owner of said land. Section 8. Easement against nuisance. Article 682. Every building or piece of land is subject to the easement, which prohibits the proprietor or possessor from committing nuisance through noise, jarring, offensive odor, smoke, heat, dust, water, glare, and other causes. Article 683. Subject to zoning, health, police, and other laws and regulations, factories and shops may be maintained, provided the least possible annoyance is caused to the neighborhood. Section 9. Lateral and subjacent support. Article 684. No proprietor shall make such excavations upon his land as to deprive any adjacent land or building of sufficient lateral or subjacent support. Article 685. Any stipulation or testamentary provision allowing excavations that cause danger to an adjacent land or building shall be void. Article 686. The legal easement of lateral and subjacent support is not only for buildings standing at the time the excavations are made, but also for constructions that may be erected. Article 687. Any proprietor intending to make any excavation contemplated in the 3 preceding articles shall notify all owners of adjacent lands. Chapter 3. Voluntary Easements. Article 688. Every owner of a tenement or piece of land may establish thereon the easements which he may deem suitable, and in the manner and form which he may deem best, provided he does not contravene the laws, public policy, or public order. Article 689. The owner of a tenement or piece of land, the usufruct of which belongs to another, may impose thereon, without the consent of the usufructuary, any servitudes which will not injure the right of usufruct. Article 690. Whenever the naked ownership of a tenement or piece of land belongs to one person and the beneficial ownership to another, no perpetual voluntary easement may be established thereon, without the consent of both owners. Article 691. In order to impose an easement on an undivided tenement or piece of land, the consent of all the co-owners shall be required. The consent given by some only must be held in abeyance until the last one of all the co-owners shall have expressed his conformity. But the consent given by one of the co-owners, separately from the others, shall bind the grantor and his successors, not to prevent the exercise of the right granted. Article 692. The title and, in the proper case, the possession of an easement acquired by prescription, shall determine the rights of the dominant estate and the obligations of the servant estate. In default thereof, the easement shall be governed by such provisions of this title as are applicable thereto. Article 693. If the owner of the servant estate should have bound himself, upon the establishment of the easement, to bear the cost of the work required for the use and preservation thereof, he may free himself from this obligation by renouncing his property to the owner of the dominant estate. And that is the end. If this audiobook has helped you, please comment down below and like and share our video to someone who might need it. Thank you so much for making us your law school buddy.